And today we're going to talk to you about the I-751 petition to remove the conditions. Sorry, I don't know what I'm doing.
It's fine. Take three. Take five. No importa. As long as it comes out good.
I-751 petition to remove your conditions on a permanent residence. Hi friends, this is immigration attorney Christian Alvarez.
And I'm attorney Anais Salazar.
And today we're going to talk to you about the I-751 petition to remove conditions on residence, or otherwise known as your green card. Who has to file the I-751 petition?
So the I-751 petition is usually for people who have obtained their green cards, but their green cards are only valid for 2 years. So this is for individuals that obtained their green card through marriage and were married for less than 2 years at the time that their green card was approved.
That's correct. So if you have been married less than 2 years at the time that your spouse petition is approved, normally immigration issues you a 2-year green card. If you were issued a green card for 10 years, even though you had been married less than 2 years, please be aware that these things happen by mistake or error of USCIS. If your green card was issued in error, you also need to file the I-751 petition. Another question or a question we get asked is when should this I-751 be filed? And the window for filing this petition is immediately 90 days before your permanent resident card expires. Now, this window is only applicable to those of you who are still living with your spouse in the same residence and will be filing as a joint petition. Now, one question that we get very commonly asked is, well, in what scenario or under what circumstances can I file my I-751 by myself, meaning without my spouse?
So there are four options for a I-751 applicant to file by themselves without their spouse. So the four exceptions are: if your petitioning spouse passed away or is deceased before they can file an I-751. The second exception is if the marriage was entered in good faith, but the marriage has terminated or was annulled. The third exception is if the marriage was entered in good faith, but the conditional resident or the conditional resident's child was subject to abuse. And the fourth and last exception is if the marriage was entered in good faith, but the termination of the conditional residence would result in extreme hardship to the applicant.
So let's take a few minutes to discuss each one of the exceptions. I think the most common questions we ask are when people are no longer with their spouse and it really worries them. I think one of the biggest misconceptions is that if I'm no longer with my spouse who petitioned for me, I'm going to get deported, my case is going to be denied, and that's it. That's the end of the world for me. So we want to take the time to explain these four exceptions because a lot of people qualify under them, and not necessarily being and not being with your spouse by the end of the 2 years doesn't mean that you're going to get denied or be placed in removal or deportation proceedings. So the first one is if your spouse has passed away after your green card was approved, but before the 2-year green card gets expired. So for those of you who have had a spouse pass away, you need to submit with immigration evidence that, of course, your petitioning spouse passed away. Now, one thing is that this type of case, you can file the I-751 at any time. You're not obligated to wait until the 90 days before your green card expires to file this petition. For example, if your spouse passed away, only 1 year into the marriage, you can file the I-751 at that time. You don't need to wait for the next year when your card is close to expiring to filing that. So the next category is for those of you who have been in a good faith marriage, but the marriage ended through divorce or annulment. So Anais, do you want to take a few minutes to explain that one, that exception?
So I think the most important here is submitting evidence that the marriage has terminated. So that's a divorce judgment, a divorce certificate, or that the marriage was annulled. Besides that, we also have to submit evidence that that it was a good faith marriage. So marriage certificate, birth certificates of children that was born into the marriage, joint bills. It's very important to submit taxes that were filed as married filing jointly, any travel, of lease, health insurance, life insurance, just any evidence that can show that you and your ex-spouse lived together and you had commingling like finances.
Yeah. A lot of people get married, and once they get over this like honeymoon phase, they realize that the relationship with their spouse is really not going to be something that is going to last forever. We have had a lot of cases where we personally meet couples that are so excited to be together, and then because either the foreign national, there was such a culture shock or language, you know, language difficulties, maybe getting used to finding the same quality of work that they had in their home country. So many factors sometimes get in the way of a relationship working out. If your relationship was real, was in good faith, you tried to make it work, but it's not going to work out for any reason, right? For any reason whatsoever, including we've even had couples that say, look, the person was unfaithful to me. You are in your right to seek a divorce. Now, under this category, you still have to show, of course, like Attorney Salazar said, you have to show that you had a good faith marriage. So even if you're getting divorced, that's okay. You can file for divorce at any time, but you still need to be able to show to immigration that during the time you were married, that you had a good faith marriage. And immigration looks at your taxes, looks at your joint bills, looks at your travel, right? If you have zero taxes, zero joint bills, zero traveling, there's a big chance that immigration is really going to question whether you married this person in good faith, right? So it's very important to make sure to find as much evidence as possible to prove to immigration, hey, yes, I'm getting divorced before the 2 years and I'm no longer living with that person, but here's proof that we did have a real marriage together, right? Here's proof that we traveled to my home country to visit my parents, right? Or we filed taxes together. We did so many things together. Here is evidence of that. So the quality of your evidence is very important um, for immigration. Again, you are entitled to get divorced, but it's important that you also have that evidence to prove that you didn't get married just for a green card.
And this makes sense because the way that immigration thinks is that, okay, if you were married, you got married for 2 years, right? In those 2 years, they expect you to have a certain amount of evidence, right? To have joint bills because you live together, that you have a lease, or if you can get a letter from your landlord saying that you rented the apartment or a room. But if you've been married for more than 2 years, which is for the I-751 petition, then they want to see more evidence than what you initially submitted in your application for the green card. So why? Because you have been married for a longer period of time.
One other thing is sometimes people ask, well, do I really need a lawyer to do all this? And when you're going to get an exception case, meaning you're filing because you're by yourself because you are going to be you are filing for divorce or you're in the middle of divorce proceedings, the reality is that it is important to obtain an attorney or have an attorney that has experience in this field work with you, because when you go into that interview, the officer is going to ask a lot of questions. The evidence people submit on their own a lot of times is incomplete, and more than anything, an attorney will help you draft an affidavit in support, meaning draft a sworn statement from you explaining exactly what happened in your relationship. Why did that relationship break down? Because the officer is a person who, just by looking at documentation alone, may not have a full picture of what happened in your relationship. Why did it break down, right? And these statements in support, or at least a statement from you, it's just very important. So working with a lawyer will help you, or your lawyer will give you ideas as to how to draft your affidavit, and perhaps how to submit additional affidavits from friends and family that knew of your relationship, knew what problems you experienced, and knew that you ended up in divorce, right? So the third category we discussed was for those of you who may be victims of domestic violence or extreme cruelty by your U.S. citizen petitioner spouse. If that person is subjecting you to abuse, um, subjecting you to cruelty, or even domestic violence, then you're not obligated to stay in this toxic and harmful relationship. You can file an I-751 as a victim of domestic violence or abuse, but immigration is still going to ask for evidence of that, just like they do for the divorce. Immigration asks for evidence of good faith marriage, meaning you have to show it to immigration, you have to prove to immigration that your marriage was real. You married this person with the intent of really having a family together, a life together, and then this person was abusive. And we also need to submit proof of that abuse. Now, sometimes proof of abuse is as easy as pulling up police reports that you filed against your spouse, showing that you went to a shelter to seek help. Or they do have around New York, New Jersey, they have a lot of domestic violence shelters available to individuals. But if you're in that situation where you didn't get to file a police report out of fear, you didn't get to go to a shelter, then you really need to think about what other evidence can you submit to USCIS. Other evidence clients have given to us have been pictures of the injuries that they sustained, letters from families and friends. We've had people submit letters from a neighbor that heard, one of our clients being yelled at and beaten and screamed at. And she said, I heard everything, right? So speaking to your attorney is a good idea, because then even if you don't have a letter from a police or a police report or a letter from a shelter, your attorney will be able to best advise you what other type of evidence can we show to immigration that you suffered domestic violence or that you were subjected to extreme cruelty by your spouse. For those of you that maybe went to seek psychological help, those reports can also be helpful in your case.
And we've also included other evidence that that people, that you don't really see in the I-751 instructions, which is like text messages from your spouse that, I don't know, using offensive language against you. Or we've submitted Facebook posts showing like that the abusive spouse is talking about the applicant in an offensive way. So everyone's situation is different, and that's why it is important to meet with an attorney, because the evidence that you submit will be tailored to your case.
That's true. We have submitted cases where we see the abusive spouse say terrible things to the foreign national in via WhatsApp or via text messages, like threats, ugly bad words and stuff like that. All of that is important, and it corroborates, and it's going to be evidence that corroborates your testimony, right? It's also important to write an affidavit or a letter, a testimony to immigration to explain exactly what were the incidents that you were abused or you were injured. And during this category, you don't need to be divorced. You don't need to have a divorce case pending. So please don't be afraid of escaping an abusive or an unsafe situation. If you think that if by leaving this really dangerous or toxic environment, you're going to be deported, that's not the case. But please reach out to an immigration attorney so that they can help you and give you best advice.
Correct. So the last exception is if the termination of the conditional residence would result in extreme hardship to the applicant. And this is usually for, there's no need to submit evidence of bona fide marriage, of good faith marriage, but you do need to submit evidence that you suffered extreme hardship during the time that you did have that, that you were married to your spouse and that you had your conditional residence. So an example that I like to give for this hardship, for this exception is, let's say if you were diagnosed with cancer during the first 2 years that you had the green card. And for this type of case, we will have to submit medical records that show a diagnosis and explaining why it is important for you to continue your treatment. Another type of situation would be if you are from a country that is in political turmoil, or and it's very it would result in extreme hardship if you had to return to your home country. So for this type of case, we will submit evidence of economic or the political situation in your country.
Yeah. So this is a very interesting and not very highly used exception. During, like Attorney Salazar mentioned, during this exception, the extreme hardship exception, you don't need to show that your marriage was in good faith. So you don't need to go back and dig up financial evidence or evidence of taxes filed together. But you do need to show, which is this is the part that gets very restrictive. You need to show that the extreme hardship that you will suffer is something that started during the first 2 years during the time that you were married to your petitioner. So this is not something that we would encourage anyone to file on their own before you make sure that an immigration attorney looks at it. And the reason for that is because immigration, unlike other cases, when an I-751 petition is denied by USCIS, they are obligated to send a notice to appear to the person. So a notice to appear is a notice to appear before an immigration judge, meaning if your 751 is filed on your own and you did anything wrong and the case gets denied, you will be sent to immigration court. And if a judge denies that case again or denies your case in general, then you will be issued an order of removal. Your green card status will, of course, be taken away, and then you will be floating around with a deportation order. So this type of case, the I-751, is very sensitive. This is not the type of case to file on your own, because if you file it on your own and something goes wrong, you're going to end up in removal proceedings. And those types of cases get much more complicated. So it's always best to file your case with USCIS the best way possible with the best evidence possible, so that once you get approved here, the next step for you will be to naturalize or to become a citizen and not have to deal with being placed in removal proceedings. And once you get placed in removal proceedings, most of our cases last a few years, right? Immigration court is not going to call you right away. And when they do call you, they're going to give you a next hearing in a few years from now. So it really becomes a big hardship to be sent to removal proceedings only because the case was not done properly the first time.
In addition to that, once your case is in immigration court, you will certainly need an attorney to represent you. So the legal fees that you avoided paying by filing the I-751 by yourself, you're going to pay much higher legal fees if your cases ends up being in immigration court.
Now, one very common question we get is, Attorney Alvarez, Attorney Salazar, I'm currently separated from my spouse. What can I do about that? Well, as we went over the 4 exceptions with you, the 4 exceptions are if your spouse is deceased, if you have filed or you have been issued a divorce, domestic violence, or hardship. Separation is not one of those 4. So if you're separating from your spouse, or you're already separated from your spouse, you do need to file for a divorce, right? If you are thinking that there may be reconciliation, then that's something you really need to discuss with your attorney, because there is no middle ground. The 751 has to be either filed with your spouse or as divorce, or maybe extreme hardship, or I'm sorry, not extreme hardship, domestic violence, or extreme cruelty. So make sure you speak to your attorney, but there is no category for simply being separated. And being separated can only really cause problems with your I-751 or your case in the future, because during that time, you're not collecting evidence that you're living together. You're not living together, right? So please make sure that you speak to an attorney as soon as possible. If your relationship is not working out, being separated is only going to be hurting your case. Talk to your attorney so they can best advise you what's the best course of action for you.
This is correct. And also, if one or more than any of these exceptions apply to you, you can apply for the I-751 under any of these exceptions. So you can use 1, 2, or 3 of these exceptions.
Yeah. If you are getting divorced and you also suffered domestic violence, you can check off both exceptions, right? So
For example,
Attorney Salazar is completely on point. You don't need to file based on just one of them. You can check off as many as apply to you.
so if more than one applies to your case, I think it's best to apply to submit the I-751 under as many exceptions as you can.
Yeah. So friends, I think that's everything we have for you. I hope that this video has been informative. If you have any questions, feel free to visit us at alvarezimmigration.com, or you can also call us at 646-453-7722. I think that's it, right, Anais?
Yes, that's it. Please feel free to share this video with anyone that might find this information helpful.
All right. Take care, guys. Thanks a lot.